Now we're going to start talking about fair use. I broke this section down. There's like 3 videos, lectures from me, and then there's some additional information that follows regarding fair use in videos and online videos specifically, when you might be able to use something or something may be deemed fair use. We're going to go over my first video is going to go over the rules and the laws for fair use. The second part is going to discuss parody and transformation of a use. And then the third is going over a bunch of cases and examples. Fair use is one of the gray areas, very gray areas of copyright law. Despite the discussion on this topic, I would recommend when using another's work, as always, you should seek permission and not rely on a self-interpretation of fair use. First and most important, courts interpret it differently. So what would be deemed a fair use in New York may not be deemed a fair use in California. There are only a few scenarios where fair use is clear cut, and that's usually news and critique. For example, news station is reporting on Lady Gaga, who's in town for a concert, and they play a clip of her recent music video for a few seconds, and then they jump back to their story. Do they need permission to do that? No, it will be deemed a fair use if Lady Gaga decides to sue for using a portion of her video, because it's under the news and comment or critique segment. So that's just a little snapshot picture. We're going to go over that in more detail. I also recommend reading and reviewing the material on fair use that is in the reading material in the book. It starts at page 423. So questions we are going to try and answer. What is fair? When is it fair and legal to use another person's copyrighted work to make your own work? And where's the line between infringement and fair use? Fair use is considered a defense to a claim of copyright infringement, meaning you acknowledge using the work without permission. You are using a work without permission from the owner, and it is used when you are using someone else's work admittedly, versus I created it myself. And you oppose the use of another work. Remember the example, the cover of New York Magazine was turned into a poster, and then the folks from the movie poster, Moscow on the Hudson. The question was whether they looked alike. There was no argument relative to fair use. The argument was we created that, and that's our own independent work. For fair use, you're saying, yeah, I used your work, but my use of it is fair. So there's a acknowledgement, and it's on that person who is saying, yeah, I'm using it fairly, to prove that they're using it fairly. So it's a defense. Remember the Khloe Kardashian photo from the right of publicity discussion? She uploaded a photo that was taken of her by a photographer. She did claim fair use. Is it fair use? Hey, it's me in the photo, so I should be able to use it. It's fair. Is there any basis for that? No, she stole somebody else's work. She took it. She took something she doesn't have permission to have. It's like stealing. So they call it, the fancy name is copyright infringement. She took somebody else's work and used it on her own website. She actually, I think, manipulated the watermark that was on it as well. But is there ever a time that you can use someone else's work without their permission? As I said, fair use is a defense, which means that the person who is using the work, who's claiming that it's fair, has to prove that it's fair. Fair use it lies right at the heart of copyright law. It's a distinctive feature in U.S. copyright law, meaning there's no other countries that have this specific exemption. Others have something that's called fair dealing standard. So this fair use standard is unique to the United States copyright law. So what is it? It's a flexible doctrine, allowing use of copyrighted works without permission and without payment. Fair use is decided on a case-by-case basis. Court's decision to predict and hard to decide when you use fair use. As I said, it's going to depend on where the case is brought a lot of times, because it's going to be determined on what the facts are before a particular court, and that might be different from court to court. It applies to all of the subject matter that's subject to copyright protection, all subject matter, and all of the exclusive rights that are relative to copyright law. As I said, before I kind of move forward, there is additional material to supplement this lecture. That other material you must watch. It focuses on fair use with using online videos, making mashups, using music in videos, when you can use movie clips and clip them together to create another work. Definitely need to watch that. So I posed some examples here. Geologist made 60 copies of a recent copyrighted newspaper article and passed them out to her public lecture a month later to show the importance of topic and diverging views of the expert. Is that fair use? Certainly copying. She made 60 copies. Can't do that. It's reproduction, but the question will be whether or not that's fair use. Advocate's editorial quoted 4 paragraphs from her opponent's recent copyrighted article in order to, methodically demolish the argument. Is that fair use? Google copies as much of the web as possible and even scans libraries of books to make a search database of the world's published knowledge. Is that a fair use? So these are the questions we're going to answer. And the answer to these is it depends. It's a close call. Do these various actions infringe copyright? Certainly they're copying. We've already talked about that, reproduction. The question is, are they going to be allowed to do that? So let's take a look at the factors here. Actually, before we get to my factors, which the statute does have factors, but these questions come up and they come down to case-by-case analysis. And it's very fact-specific. Hard to determine if you're a person who wants to use something. Think of a teacher including material in a course work or course pack. Yes, there's rules regarding and exceptions for teachers, but they're very limited. A writer quoting lengthy passages from a letter, a documentary filmmaker who captures others' images or music in their footage. That's going to be answered in the other part of the video. Online videos also applies to filmmakers. A student group that would like to show a film. The maker of a mashup. All of these things could potentially be fair use. There's a lot of common misconceptions. Let's clear some up. If you're not profiting from it, you can use it. That's a false statement. Everything on the internet is fair game to use. That is a false statement. I'm just using a portion of it, a piece of it. That is not an accurate statement, as you have at least seen relative to the music discussion. Could be a de minimis use, which would make it fair. But a lot of cases, not so much. Educational purposes only. No, that's inaccurate. But I'm giving the owner credit. If I give the owner credit, is that fair use? Not necessarily. Well, there was no copyright notice on the work, so I thought it was in the public domain. That's another misconception, heard often. How about a pre-1972 song recording? A recording. Is that fair game? No, we've talked about that as well. It might be protected under state law, but as of 2019, federal law has encompassed pre-1972 songs in its library. So it's not necessarily a fair use. It's going to depend on how it's being used. So let's talk about some examples, or let's actually talk about the statute, 17 U.S.C. 107. First, The courts consider whether the use at issue falls into one of these specified uses. If it does not, highly unlikely it will be fair use. Criticism. Is the new work criticizing the original work? Are they commenting on it? Is it being used for news reporting? Is it being used for teaching, scholarship, or research in some fashion? That's the first part of the analysis. You have to look to see if it's in one of these items, one of these factors, or one of these issues. The example I gave you above regarding Lady Gaga, right? News reporting. How about this one? This was a couple years back where a man who used Facebook to live stream the birth of his child sues ABC, NBC, Yahoo, CBS, a whole litany of news organizations. What happened was he accidentally publicly streamed his wife birthing their son. He had intended for the stream to only be viewable to friends and family, but had instead made the stream viewable to pretty much everyone. Even after realizing, though, he's done so, he kept the stream public, which led to over 100,000 views from people of the video, including several news organizations who then used parts of the streaming in a news story about the couple's decision to stream the most intimate of moments. So he sues all of those news outlets. What do you think? Fair use? Because that's what all of the news outlets claimed when he sued. And the court, and I hope you're saying, oh, yes, that's absolutely fair use, because that is the example, as clear cut as you're going to get, as like the Lady Gaga example. Criticism, comment, news reporting. Yeah, that was a form of news reporting. The court tossed the case out even before it got started, saying that is, the poster child of fair use. They're using it, a portion of it, not the entire thing, for news reporting. So, first step, look to see if the work that you're using, or the new work that you're creating, falls into one of these things. You're going to criticize the original work, comment, news reporting. Is it being used for news reporting, teaching, scholarship, or research? Then we move on. Even if it falls into one of that, that's going to make it really high on the list for fair use, but it still has to meet the other four factors. And the four factors that court considers: purpose and character of the use. How is it being used? How's that original work being used? How, the nature of the copyrighted work, the original work. The amount or the portion of the work being used in relation to the entire copyrighted work. And the effect of the use upon the potential market for or value of the copyrighted work. And the courts engage in weighing these factors, and the court then decides whether fair use applies. And all these factors are interdependent. They all should be and do have to be taken into consideration. The final one has slightly more weight. We'll talk about that in a minute. But all of them have to be considered. The court can't just say, oh, nope, after factor one, and say no fair use, or yes, there's a fair use. It has to go through the whole test of all four. Let's go through some of these. So the purpose and character of a use. And it includes whether such use is of a commercial nature or of a non-commercial nature. And just because a work is of the new work is characterized as commercial or able to make money, does not necessarily take it out of this fair use. You could certainly make money on a new work, but it's certainly something that's considered. And the fact that it's not making money doesn't take it out of, oh, well, they're not making any money off of it, so it should be fair use. That's not it either, but that is something that is considered, the purpose and character of the use. So, despite the fact that commercial uses are kindly less likely to qualify, it's not going to take it out. Private non-profit uses, more likely to qualify, but not certainly, they don't have immunity against it. So others, productive uses, how's it being used? Is the work used as part of another activity? Or is the work being transformed in some way, a use of a work that makes another creative work? And I'm going to talk about this transformative use in much more detail in the next video because there's a lot of cases on it. But I don't want to muddy down the 4 factors. I just want to give you a snapshot of the 4 factors. The next video is going to talk about transformative and parity, and then we're going to go through a list of cases. But this is where the transformative test will take base. What's the purpose and character of the use? Was it transformative in some way, or are they using the exact copy, or did they manipulate it in some way to create another work? What are they using of the works? Are they the unprotected aspects, the exploitation of unprotected aspects, like the Senefer of the copyrighted work, or are they actually using the copyrighted work? Was there good faith? Did the user, there's going to be a consideration of good faith, whether the defendant's actions or the user tried to get permission of the copyright owner, or the reverse, you obtained it by theft or some breach of contract or some other bad actions that would weigh against you. That's considered, well, I went to try and get permission, but they denied me permission. And I think I have a claim of fair use here. So that's the first factor, purpose and character of the use. How are they using the work? The nature of the copyrighted work. Now we're looking at the original work. How creative is that copyrighted work somebody is using? The more creative or has creative expression, the more protection it's going to get and weigh a little bit less against the fair use argument. But works that are, factual in nature, a history book, a scientific work, telephone directory, those non-original type works or functional works, not so much. Are we talking about Harry Potter? Or are we talking about JFK's assassination? Right? While those books might be copyrighted and how they're created, clearly Harry Potter is by far more creative than somebody who gathers the factual information about the Kennedy assassination and puts that, it's a history book, and puts that together, and that the content in there, and what are they using? So what's that nature? That copyrighted work? Is it factual? Is it non-factual? Is the work out of print, or is it readily available? Is the work consumable or have only one purpose, such as workbooks or such as crossword puzzles? If you do a crossword puzzle, it's all over, right? You can try and erase them out, clear it up. There's really only one use. Is the work consumable or have one use? What about unpublished works? That's something that has to be considered, whether the work is unpublished or published, and it is highly unlikely going to get a fair use defense. It's going to weigh heavily against fair use if it falls into the category of unpublished, because as we said earlier, the owner has the valuable right to publish first and says who gets to publish first. So if a published work is obtained wrongfully, there's no fair use. If there's a work that is obtained maybe not wrongfully, but somebody obtained it in some fashion legally and then they publish it, the chances still are very hard, because getting the option to have it published is a right to the copyright owner. And that happened in Harper versus Row, went all the way up to the Supreme Court. The plaintiff, who is Harper Row Publishers, obtained the rights to publish President Ford's memoirs, which was called A Time to Heal. Time magazine contracted for the rights to preview the work immediately before the publication. But before the publication of the article by Time magazine, Nation Enterprises, the publisher of Nation magazine got a copy of the manuscript, Ford manuscript, and the Nation published an article that quoted the manuscript about the Nixon pardon. Time magazine then chose not to use the article as planned and canceled its contract with Harper and Row Publishers. And of course, there was a lawsuit, and the question was whether or not this is fair use. And of course, after what we just last discussed, Nation Enterprises went, we did it for news purposes. We took a portion of it and we published about it. That's news reporting, right? That sounds like it hits right up in the categories. But guess what? The court said, whoa, the publication of parts of a work that are soon to be published does not qualify for a fair use. It is not reasonable to expect a copyright holder to let another person, quote unquote, scoop it by publishing his material ahead of time. The court did consider the other two factors that I'll go over when we get to the other two factors, but considering the nature of the copyrighted work, they were already deeming this is not going to be fair use if it's been unpublished. So, and this also happened to Sarah Palin when her book came out. Gawker Media got a copy of it ahead of time, and it released 20 pages of the book, not released. They copied it word for word, 20 pages of the book. I mean, the book, I think, was a couple hundred pages long, but still the book had not been released yet, and the court deemed that was not a fair use, despite it was only 20 pages. The question then became, how important are those 20 pages? If it was, the heart of the work, but nonetheless, it turned on this publication, whether it was published or unpublished, and how the owner has the right to choose where it gets published first. So that's going to be considered relative to the nature of the copyrighted work itself. So then our next factor, the amount of work. What are we taking? The amount and the substantial portion of the work is going to be looked at. Obviously, if you're copying the entire work, it's less likely to qualify for fair use than only a portion of the work. So let's say we take a song and you like the lyrics of a particular song. Let's say it's a love song. I don't know if Lady Gaga has a love song. Let's say it's a Lady Gaga love song, and you copy down the entire lyrics word for word, and then you go on your radio show or your news show and you read those lyrics, but you read it in a way that is, different in how you present it. You maybe present it more like a poem. And the question is that going to be fair use? You can be allowed to do that. You took the entire lyrics and put it out there, let's say for broadcast. Let's say you're on the radio or you're on TV. It's highly, even though you're not making any money off of it, and the work is highly creative, as we head into step 3 here, that might weigh against you. That's going to tick up against a no fair use argument. So copying the entire work is less likely to qualify for fair use than only using a portion. But sometimes fair use protects the entire work. Doesn't protect the entire work, like facts from a factual book. There might be little protection in that expression. But also the heart of the work. If you're taking the heart of the work, let's talk about Martin Luther King's "I Have a Dream" speech. The heart of the work. It was a 20-minute speech. But what do we all always see and hear that's out there? I have a dream. There's just that heart of the work, that portion. So the question is, can you use that without permission? It is not in the public domain. That speech might have been done in 1963. but it's still owned by his heirs, and we've talked about that case. So the question is it using the heart of the work? The key, whether the amount taken is appropriate to the favored use, i.e., see that list above, news, criticism, research, comment, teaching, right? Is it appropriate for that favored use? Whether the copier took an amount that is fit for the purpose of the use, i.e., whether the reviewer quoted only sections relevant to her analysis of a book, taking a quote, from a book for a critique or an article. Was there an alternative to taking the portion copied? Was the portion you are using the facts, the savoir faire, or the heart of the work? You have to consider that. In the Harper case, the magazine could largely have accomplished the favored purpose of news reporting by copying the unprotected facts and ideas and non-original elements, that stuff we already knew that was out there relative to the Nixon pardon. Whether the amount taken was likely to diminish, that's my next question, and that's where we're going to go to. The question is the effect. Here's the questions that I just went through. The key, whether the amount taken is appropriate to those favored uses, whether the copier took an amount that fit the proposed use, was there an alternative to taking the portion copied, whether the amount taken was likely to diminish a potential market for the copyright, that question leads us into the next factor, which is the effect on the market. So you're taking whatever portion that might be, is it likely to diminish a potential market for the copyright owner? And in the Harper case, just before we head into the details of this, is the effect on the market of such a use is shown by what happened in the Harper case. It greatly decreased the market value of the copyrighted work. They lost the time contract. That's an obvious effect on the market. So this factor, the effect of the use upon the potential market for or value of the copyrighted work, this factor carries a little bit more weight. It's not the trumping factor. If it says, it affects the market, boom. No, that's not it. The court has to look at all four, but this one gets weighed a little bit more. And this factor, because it carries more weight, can negate, the fair use. One need only show that if the challenged use should become widespread, that it would adversely affect the potential market for the copyrighted work. The inability of that copyright owner or the plaintiff, the one who claims infringement, the inability of that plaintiff to demonstrate an adverse economic impact from the copyright can frequently in and of itself allow for a fair use determination if they can't prove that there's this effect on the market. So the ways to show market harm: lost sales of the copyrighted work, harm in the market that the copyright owner is likely to enter. If defendant's use became a widespread practice, they'd suffer, the market would suffer harm. Verbatim copying of the original in its entirety for commercial purposes is going to be presumed a market harm. Also, in evaluation of the economic impact, the court considers not only the direct impact, but also the impact the using of the copyrighted work might have on some derivative creation. Is the new use stopping the original owner from pursuing a derivative creation? They may or may not choose to. They don't have to, but it's a right that they have. When a work is criticized, it's on that list of fair use, but the question becomes, does criticism lead to a decrease sales? Let's say someone's book is out there and the book gets reviewed, right? This happens all the time. You get on Amazon, you read all the book reviews. I don't know if they sway you one way or the other. It should be an interesting poll. They don't particularly affect me. If I want to read something, I'll read something because everyone's kind of different in what they like. But when a work is criticized, So in a book review, you can totally do that. Criticism is on the list for fair use. And then you follow the factors. How much are you using it? What's the purpose? And you go through the list. But we all know a book review will meet fair use standards. But then, like the claim is, does the criticism lead to decreased sales? Well, your bad book review, nobody bought my book. Is that enough? With that, can you sue for copyright infringement? Affects the market? The answer is no. The exchange of ideas, the First Amendment. That's protected speech by the First Amendment. We're going to do some examples. We just finished up talking about the law, the factors. I threw in some cases there. The next step is to talk about what that transformative test is and what constitutes transformative underneath our first element of the purpose, as well as talking about something called a parity. I've seen that written in some of your assignments. Now you'll know what exactly the parity is and how it plays a role in fair use. And then we're going to go through a bunch of cases and put the test together.